Good evening, everybody. I'm told there are not just 70 of you sitting in this room, but there are 200 people listening online as well. So what a wonderful reaction to this event. My name is Christopher Floyd. I'm an on-prof at UCL and IBIL. IBIL stands for the Institute of Brand and Innovation Law, but that is a broad church, and the topic tonight is within it. It's about information, it's about secrecy, it's about confidentiality, it's about protection of sources, it's about privilege, and all those things. I'm very much looking forward to listening to it. But my job is simply to welcome you, to thank you very much indeed for coming tonight, and not to introduce the speakers, but to introduce the chair of this evening, which is the amazing Professor Amanda Harcourt. She is a miracle worker. Anyone who's attended her course, as I have, on data and privacy law will know that. She has the power to bring in the most amazing speakers as well, and this evening is no exception. So over to you, Amanda.
Thank you, Sir Christopher. Actually, these public lectures precede the annual courses on privacy and data law and practice. Next year is the 9th year that we've been running them here, and there's still a few places left if you're keen. The subjects this year will include the forum internum, international data transfers, data broking, sales, ad sales tech, the press and reputation, a review of AI legislation worldwide, such as it is, and the governance of biometric data. But there are two other slots. One is looking at whistleblowing, and the other is examining how a company might respond if they receive a request under the Investigatory Powers Act. We're very lucky, I'm so excited, to have with us two people who have learned firsthand about working with the IPT is what it's like. And before I'd introduce them, I think it's worth making just two observations. Firstly, there is a chance that some police forces might not emerge from tonight's discussion smelling of roses. So I'd just like us to remember that they're often in an invidious position. They have to keep order in large gatherings when people are armed with cameras and filming, checking up on what they're doing. But they're called upon to attend pretty unpleasant scenes of violence and misery. Secondly, we are here to explore issues relating to press freedom, but I'll see if I can read out these names without losing control. We should actually take a moment to remind ourselves of some people most directly affected by the Loughinisland massacre. They're behind us. Adrian Frosty Rogan, Barney Green and his nephew, Dan McCreenall, Patsy O'Hare, Malcolm Jenkinson, who left a widow and 3 children, Eamon Byrne, who left a widow and 4 children, as well as the 5 injured, and the close-knit community of Loughinisland. So to tell us about the consequences of that night 30 years ago, I'd like to welcome Barry McCaffrey, journalist, filmmaker and author, Trevor Birney, and Casey Ben Jaffey.
Thank you very much to Amanda for that wonderful introduction, indeed to Christopher and to Lisa for the invite. This feels like a kind of a travelling circus. We've been on the road now for several years talking about this case and its various iterations. But as Amanda said, really the events start in this little bar, which is less than 20 miles from the city of Belfast. The Heights Bar is a family-owned local pub. You know, it's like any other village pub. Across the road there is a Catholic church and a cemetery, and it's an incredible rural area. Farmers come in here after finishing a day's work, and on the night in question, 17-year-old Adrian O'Toole was behind the bar, and you can just about see a television slung up under the brown Formica facade at the top end, and on that television on the 18th of June 1994. Everyone in the bar was standing with their back to where the photographer took this picture, watching a soccer match between Italy and Ireland that was taking place at the World Cup in America that year. And the first half of the match had started around 8 o'clock, and everyone was cheering on the Ireland team. They went 1-0 up due to a Ray Houghton goal, and you can imagine the excitement as it looked like Ireland could overcome the incredible Italian team that ultimately would go on to the final that year. So they were standing with their back to the television, and shortly after half-time, there was a noise that initially sounded something like a firework. One of the witnesses, one of the survivors, described it that he thought somebody had thrown a squib into the middle of the bar. But unfortunately it wasn't. Instead, it was a man over 6 foot tall, dressed in a boiler suit and a balaclava, and he was wielding what's known as a VZ-58 rifle with a full magazine of about 38 high-velocity bullets, which he immediately unleashed, spreading the bar from left to right. On the left-hand side was Barney Green, 87 years of age. That's his whiskey. You can see just sitting on the table beside him was his nephew, Daniel McCraner. And the rest of the victims were spread in a semicircle left to right along the bar watching the TV. 5 men were injured, and it was a massacre. And it was a massacre. The only motivation was the fact that the people in the bar were Catholics. This was at a time in Northern Ireland where there was great hopes for peace. Sinn Féin President Gerry Adams and the SDLP leader John Hume had been speaking for several years, and the fruition of their private discussions were starting to come into the public domain, and everyone was beginning to get very excited that the prospect that a conflict that had gone on for 25 years was coming to an end. And in some regards, the loyalists who entered that bar knew that and wanted to prolong the conflict by causing as much death and disaster as they possibly could. And they did. 6 men died, leaving many, leaving widows, children, and a community that still today bears the scars of that night. In the immediate aftermath, this gentleman, Sir Patrick Mayhew, who was the Secretary of State for Northern Ireland, visited the bar. That's the bar that you can see behind him, which is basically like a double-storey family home. And said the killers will be caught. The police force, the RUC, will never give up. They will not stop. They will bring those who have committed this massacre to court, and they will go to prison. That was the promise he made on that day, and that was the promise that really, for the families of all those people who died, they took to heart. They believed fully that the RUC would commit themselves to bringing the perpetrators to justice. And for several years afterwards, they didn't speak to the press. They didn't give any interviews. They didn't make any comments about the RUC. They didn't speak out and criticise the RUC. They put their full trust in the state. Despite being nationalists, Catholics, they absolutely supported the RUC in their campaign as they told them to leave no stone unturned and go after the killers. In fact, a senior detective sat in many of the homes and sat at kitchen tables over teapots and cups of tea and said, "We will leave no stone unturned." If we go forward to 2011, and by that stage, the killers were still at large. No one had been brought, no one had been charged, never mind appeared in court. And Barry McCaffrey and I began to work together on an investigative website called The Detail. And Barry, whose family come from this area, brought with him an inherent interest in going after the Loughinisland case and started to investigate what exactly had gone wrong with the investigation. That led to Barry writing a number of very significant reports for The Detail, which are still on the website today. And somebody somewhere began to realise that Barry was very interested in Loughinisland. And one morning, a brown envelope appeared at our offices, and inside it were 2 top secret documents called Scope 1 and Scope 2. And those two documents pull back a very dark curtain on collusion between the RUC and the Loyalist killers. Barry immediately realised the significance of it and protected those documents. We examined them. We believed them to have emanated originally from what's called the Police Ombudsman of Northern Ireland's office. In the aftermath of the Good Friday Agreement, several new institutions were set up. A number of institutions were set up in order to hold the police to account. The sort of accountability mechanisms that weren't there in the RUC pre-1998. So the new police force in Northern Ireland, the Police Service of Northern Ireland, would have a policing board that would have a number of politicians and independents that would sit on it. And it also would have the office of the Police Ombudsman. And that Ombudsman's office would be the office you would go to if you wish to make a complaint about the PSNI, be it the way that a traffic ticket was handled, to a concern that your loved ones had suffered from collusion at the hands of the RUC and Loyalist paramilitaries. And that's what the families did. The families made a complaint, and back as far as 2006, by 2011, when Barry and I began to work, there was still no report from the Ombudsman. So we began to investigate, and at the very same time, I was working with an Oscar-winning documentary director in New York called Alex Gibney. He had made a documentary called Taxis to the Dark Side, which had won an Oscar, which had revealed some of the American crimes in Afghanistan and Iraq, which had been covered up. That collaboration between myself and Barry and Alex Gibney led to a film which we titled No Stone Unturned. And we decided that we were going to indeed put the documents that Barry had been leaked into that film, and because we feel and we felt very importantly that they were of great public interest and great significance. So we had legal advice the whole way through. What the documents gave us was four chief suspects: the man who stood in the boiler suit and fired the weapon, the man that stood behind him with a revolver to protect him, the man who drove the car, and the chief suspect's wife, who had happened to write a letter in the aftermath of the attack to a local councillor, basically saying her husband had carried out the massacre. Of course, the police had done nothing with that letter. We decided that we would do something that really wasn't what we normally would do, and that we would go to the PSNI and say, we are going to name these suspects. So we went to a meeting at PSNI chief, at the PSNI headquarters. We met with an assistant chief constable, and we told him that we were going to name these four suspects. And that was a very important meeting when later we found ourselves under arrest indeed. On the day of the premiere in Belfast, the assistant chief constable that I met, Stephen Martin, made a statement, and he announced that there was going to be a further investigation into Loughinisland. However, somewhat disappointingly, he wasn't going to prioritise going after the killers. Instead, he was going to go after the journalists, i.e. myself and Barry, for having the audacity to put the documents into the film. He believed that this had put the lives of the suspects in danger and had breached the Official Secrets Act. Like all announcements around leak inquiries, we were just slightly suspicious, and we thought it would blow over and there wouldn't be very much to be heard about it. However, we were wrong. On the 31st of August 2018, Barry and I were at our homes in southeast Belfast when dozens of armed officers arrived at our doors and arrested both of us. They searched our homes, they took away our computers, our phones, they took away my wife's phone, my daughter's phones, they took even away a USB key with my 14-year-old daughter's homework on it and my 8-year-old's pink telephone. They also then went to our offices downtown in Belfast, and they downloaded everything that was on our server. So every file, every document, every documentary, whatever we ever had made over the previous years, had all been uploaded onto that server. And only 3% of the memory of the server was in relation to No Stone Unturned, but the police took 100%. They lifted notebooks belonging to journalists that they knew and recognised and admitted had nothing to do with those stood unturned. They lifted those notebooks. They lifted documents in relation to alleged sex abuse within the Catholic Church, another issue that one of our journalist colleagues had been investigating, and they took those all away. While Barry and I were being held in separate cells in the terrorist suite at Musgrave Street Police Station, our lawyers came to us. One of them we're glad to see is John Finucane, who's with us tonight. And the lawyer said that there is an opportunity to go for a judicial review here. We believe that the warrants that were issued for the searches of your premises, for the search of your homes, and indeed for your arrest, we think those warrants were issued unlawfully. And we think you should go for judicial review. Sorry, I'm just going through, that was the Premier in New York. Barry looking somewhere else, obviously, rather than at the camera. This gentleman is the Senior Investigating Officer, Darren Ellis. It was Darren who decided to arrest us. He's actually attached to Durham Constabulary, and he had been called in by the PSNI to investigate the leaks of the documents because PSNI couldn't investigate itself. So Darren was given the job, and he'd come to play a full role in our lives over the last 8 years. We were released that night, not after. This is looks like somebody said, look, boys own have gone to hell. We were released that night, but not without the success that John and his colleagues had, Niall Murphy, Barry McDonald, and etc. And what they had won was an interim injunction against the PSNI and against Darren Ellis for that they had to basically bag up all the evidence they'd taken from our offices, and we're not going to be able to look at it until a full judicial review was held. That JR was held the following summer, and we won, hands down. The warrants were deemed to be unlawful, and the PSNI was told to give us all our computers and phones, and my daughter's phones and Barry's iPad, etc., back to us. But during the case, we had received significant disclosure. In order to prepare the case for prosecution, the PSNI had indeed gone to the chief suspect in the Loughinisland massacre to take a statement from him. Unfortunately, not about his role in the massacre, but the damage that had been caused to him as a result of being named in the documentary. Now, the chief suspect had taken on a new career post-conflict and had gone into the business of rat extermination. I kid you not. And he said that, in the statements that we've seen, he said that he could no longer conduct his business in certain parts of the north of Ireland because nationalists would be suspicious of him, given his the PSNI suspected him of carrying out not only this massacre, but a number of other murders and attempted murders. But one of the documents also that was disclosed just mentioned two words, and that was a covert operation. And that really wasn't examined in the judicial review because it very much primarily focused on the granting of the warrants and how the warrants had been granted. But we noticed it, and after the judicial review, we decided that we were going to pursue this, and Gavin Miller KC had represented Barry, and he talked about this gentleman, Ben Jaffey, and that we should speak to him because we should lodge a complaint at this court that we'd never heard of called the Investigatory Powers Tribunal. And really, indeed, we had never heard of it at all before. It says something about its secrecy. And so we duly lodged complaints with the IPT in around May, June 2019. And we heard nothing. The PSNI subsequently paid us significant damages. Amnesty International, NUJ, press freedom associations around the world supported the case and saw the victory at the judicial review as a very important victory for press freedom. And really what had happened is the police had gone into court and misled the judge in an ex parte application about us, and misled the court about exactly what their intentions were. And at one point the judge said to the two police officers in court, "So is this about shooting a couple of crows in a field? in order to scare the rest of the crows out of the field, and the policemen more or less accepted. That's exactly what this is about. We feel that this operation against us was intended to send a chill factor into journalism in Belfast and beyond, in order to put journalists, investigative journalists, off pursuing issues of legacy in the north of Ireland, which still are so contentious. So many families, just like the Loughinisland families, are still seeking truth today. And despite the British government's, it's a wonderful picture of us all with John Finucane there himself. But so many families are seeking truth. And it is the role of journalists and to go after that truth. Justice is long gone. Many families, the vast majority of families, in fact, I would say all of them will never see justice. But they are due truth, and that is the role of journalists. Barry, do you want to take on from here?
Lovely. Trevor, can you hear me? Yeah. I'll try and speak slowly, because nobody understands me. As Trevor says, yeah, we got our JR. We'd been on bail for the year, and we used to have to give, if we were leaving the jurisdiction, we'd have to give 3 days notice to Darren Ellis and permissions and all of that stuff. So we got the JR, and we, as Trevor says, we put the application into the IPT, and we'd forgotten about it. We'd said, right, this is part of our lives that is over. It's finished. It's gone. We've found out as much as we can find out, and we'll move on with our lives. And that was until March the 16th, 23, and this email dropped to John and Niall, saying that the IPT had been investigating our case in closed sessions with the PSNI for this last number of years, and they had decided that there was a case to answer, or there were issues that needed investigated. What's a bit difficult to take is, somebody who robs your house, or steals from you. The offender goes into court and is allowed to put their case forward. We are the victims, and we're not allowed to know what's going on. That, to us, these closed hearings and closed material procedures, if something is national security, of course, things have to be behind closed doors. But we find that the PSNI and different UK police forces are hiding behind the issue or the identity of national security to hide all their wrongdoings. So when we find out in March 23 that we've a case back on, and the first disclosure that we got at that time told us, right, sorry, we're not actually, our complaint was about Loughinisland. What surveillance were we under in 2018? But the IPT said, no, sorry, we've identified a case 5 years earlier, and we're going to investigate that first before we even decide whether we go to 2018. So, and they don't actually tell you what the case in 2013 is about. You have to actually go and find it out yourself. If you're unlucky, or if there aren't enough facts, you'll never know actually what they're investigating. We were lucky enough that we were able to put timelines together, and we were able to identify the actual issue. So the issue in 2013 was I had been writing for the Detail and for Trevor about an issue called retire, rehire, where the police, lots of PSNI officers were taking lucrative redundancy packages and were being reemployed within days as civilian contractors. This was being done by a recruitment agency. It was worth tens of millions of pounds. And there was serious concerns about that the money public money wasn't being used in the proper way. And I had found out that the head of the PSNI's human resources was being investigated for alleged corruption. The allegation was that he was taking illegal payments from a recruitment agency. So I had made a phone call to the police press office, which is what every journalist does. Journalists phone up press offices, they ask the question, you get your reply, you move on. I had asked, can you tell me, if the status of the investigation? That's all it was. It was a simple, two-line request. What we didn't know was that once I had made that request, that the PSNI had then gone on to try and identify my sources. Now, as journalists, it's sacrosanct that we protect our sources, but we also have protections in law, to protect sources. The police know that, and it's up to the courts. There's a procedure called a production order. If police want journalistic notes or journalistic material, they can go to a judge, seek a production order. The judge, we're there, the police are there, the judge decides, and it's a transparent, it's an open, it's a fair process. The police didn't do that in this case. They used an internal process to seek my phone records. Once we saw the disclosure, the internal applications, the whole way through it, they referred to myself and actually other journalists as criminals. They say, this man is a criminal, he's associating with criminal suspects, we need to identify his sources. And it's quite clear in the disclosure that it's just about identifying sources. And that's unlawful. The police know there is a lawful way to do that, and there is an unlawful way to do that. And the PSNI chose to go the unlawful route. Eventually, as the case went on and the disclosure was going on, they then came to the IPT then indicated they would investigate 2018, the Loughinisland issue, myself and Trevor's arrest. Every time there was going to be a court hearing, the PSNI would drop the disclosure on the last day, at the last minute, on the last day. They were dragged kicking and screaming, and actually, I believe, misleading the IPT. When we finally got to, in last October, when we finally got to our full substantive hearing, the PSNI had disclosed that they had operations against me on 5 different occasions. One was when I was meeting trade union officials within the police force. That was about trade union issues. There was 2 trade union members of the PSNI who were raising concerns about the working practices of their union members, and the police decided that that was legitimate to go after my phone records and their phone records. That was 2008. 2009, the police told me we have information that you're going to be killed by loyalists in 48 hours. We then found out that the police actually used that issue to go after my phone records again. Now, the courts, or the disclosure in the IPT showed us that the supposed death threat had been made from a public phone box to the police. So why did they need to have to go after, why did they need my phone records? The death threat hadn't come to me. But again, they go after the journalist sources. Probably the biggest case, or the biggest issue came in 2011 when the PSNI, there was an issue within the police ombudsman's office. We had been leaked different documents, and the ombudsman had made a complaint to the PSNI. The PSNI couldn't be seen to investigate a complaint from its oversight body, the body that is supposed to look at the PSNI. So they called in the Metropolitan Police. The Met sent me a letter. We'd like to interview you. We replied through our lawyers. Everything we published, we stand over. We never heard anything more about it. When we get to the IPT, we found out that the Met had then launched a spying operation or phone data collection, not on over a 3-month period in 2011, not just against me, but against Trevor and 14 other journalists from the BBC, the state broadcaster. We found out in that 3-month period, the Metropolitan Police, acting on behalf of the PSNI, went after. We worked it out eventually. It was 4,000 phone, text messages, and phone calls. Now that's a UK police force spying on the national broadcaster, and that's why our whole issue, and to be quite frank, we have failed, was to bring this case is not about Northern Ireland. Yes, the Loughinisland atrocity and everything else, but our actual case was about press freedom. Our actual case was to defend press freedom, and it wasn't Northern Ireland. So we would come to London, we would go to Wales, Cardiff, Glasgow, Manchester, Newcastle. We went everywhere to try and explain to people, this isn't two paddies, this isn't about the Troubles. This is about journalism and the protection of sources and press freedom. And when we find out at the IPT that the Met are spying, on the BBC, once one interception or one comms data or a couple of texts, that's you can forgive that. That's okay. 4,000, that's industrial. That's and when did this start? Who dreamt this up? Where did the playbook come from? Because we don't believe that the Met were doing it on their own. We don't believe that the PSNI have dreamt this up on its own. How to spy on journalists? In our case, what we found out in the disclosure again was the PSNI say to Darren Ellis, well, we have a defensive operation which we run, where we listen or we listen or look at journalists' phone calls every 6 months. But don't worry, it's only to identify police officers leaking things to journalists. Now you could say that's fine, that's okay. But when we looked at all the data that the Met was looking at, it wasn't police officer to journalist, it was journalist to journalist. So that wasn't to try and find a few rogue police officers. That was to listen and to identify what journalists are doing in their daily work. That's, what is this, North Korea? Well, this is supposed to be, the mother of all parliaments, the democracy. We hear quite rightly when we criticise other countries for draconian, attacks on freedom of the press and press freedom. We criticise that, but this is going on in the UK. This, and as I say, where we have failed is probably only a few people in this room tonight actually have ever heard of our case. You know, we believe if this had happened in Glasgow or in Cardiff or wherever, they would be shouting, you know, people would be shouting about it from the rooftops. There would be a public inquiry. But none of this happens. You know, we found out in the judgment in our case, we found out that the police, on the day of our arrest, the chief constable at the time had signed a thing called a directed surveillance authority. And that was to spy on a civil servant who worked in the police ombudsman's office, who they suspected was our whistleblower or our source. And they put this man under surveillance for 2 weeks, thinking that as soon as we were released from police custody, that we would meet him the next day. He would hand over documents to us, and they would jump out of the bushes, and they would arrest us all again, and we'd be carted off, and everything would, their whole case would stand on its own. Of course, that didn't happen. But that directed surveillance authority was unlawful. The IPT ruled that that was unlawful. The chief constable hadn't properly assessed what he should have done before he signed this authority. But that chief constable, he's never apologised. He's never spoken publicly to explain why he did what he did. You know, why? Nobody will ever be held to account for what has happened to us and for the spying on the state broadcaster, on the BBC. You know, we believe if it happened in Manchester, you know, the BBC would be shouting about it in Manchester, rightfully. You know, why is it that when it happens in Northern Ireland, we hear nothing? But if there's a take home tonight, you've got to be wary, because it is happening here, and it's not just happening to journalists, it's happening to lawyers. Because we found out in Northern Ireland, the chief constable told the policing board that there had been, over, I think it was a 10-year period, that there had been applications to spy on journalists, or the data, seize their data, 320 journalists, 500 lawyers. 500 lawyers, you know. We know from the same document that they have used CHISs, covert human intelligence sources, on 4 occasions against lawyers and journalists. You know, these are probably what is most frustrating from the IPT, and we're very thankful that we got the chance to go through the process. But what was most frustrating is what we didn't hear, what we never learned. There were countless closed hearings that the other side, the police, the people who had done wrong, who had been found to be unlawful, they were able to go in to these secret hearings and put forward their defence. Ben wasn't allowed in. John wasn't allowed in. Nobody in our side was allowed in. And that's frustrating. That's that's the way. We were lucky. We were lucky that we got a process. We have lots of colleagues who've made complaints, similar complaints to the IPT, and they've been told that their cases aren't going to be heard. They're not going anywhere. I'll pass it on to Ben now. Would just like to say, it was an honour, as Trevor says, to watch Ben in action, to see his legal mind, and it was like sitting on the front bench at a football match, because it was a pleasure to see. Sorry, Ben.
Before Ben says anything, I was very interested that came out of the privacy courses I run, to stumble across a statutory instrument that was passed in November 2023, around the time of the Online Harms Act. When we were in the EU, our right we had as a fundamental right and freedom the privacy in respect of our personal data. Half a page statutory instrument was passed because of the need to alter British law because we came out of the European Union, and the definition is no longer in relation to our personal data. It's defined under the Human Rights Act, the UK Human Rights Act, and it's now only in relation to our personal correspondence, which is a very different thing. So now, Max Schrems, for example, couldn't have brought his cases in the UK are based on personal data. He'd had to use privacy law. So now what we've got is a right under GDPR in terms of control and processing of our personal data, and by contract under terms and conditions. It's no longer a fundamental right. It's only in respect to the privacy of your personal correspondence. I've been arguing with Sir Robin Jacob about this. He thinks it's a cock-up. Well, next week I've had some research done, and I think it was deliberate. Ben, over to you.
Hello. I had the privilege of representing Barry in the Investigatory Powers Tribunal, and my colleague Stephen Toll represented Trevor. I've also got a cold and I've been in court all day, so I'm going to lose my voice. I'm just going to cover four things. First of all, what this kind of weird IPT place is. Secondly, looking around the room and seeing some familiar faces, I suspect many people here are either lawyers or journalists. So I'm going to talk about how the IPT has sought to protect both lawyers and journalists. Thirdly, just a teeny bit about Trevor and Barry's case, and then finally, what next? So what is this rather strange court that most people have never heard of? Well, it's a surveillance and national security court. It usually sits in London. It's staffed by judges from around the United Kingdom and senior barristers from around the United Kingdom. It was created in 2000, at which point not much happened for about 12 years. It heard 1,000 cases, although it never found in favour of any applicant against the Security and Intelligence Services. GCHQ expressed their views privately. Unfortunately, Edward Snowden got a copy of their views and gave them to The Guardian, and they described the IPT as so far always found in our favour, and they were very enthusiastic about its jurisprudence, even calling it a selling point for the Americans. Which is an unwise thing to write down, but I very much enjoy reading those documents out to the IPT so that they knew what the litigants before them thought about them. There was an initial flurry of litigation there after Edward Snowden disclosed lots of documents, and regardless of whether you think his head should be on a spike or on a statue, it certainly triggered a lot of interesting things happening in the IPT. It was a very strange place back in 2012. It didn't feel like a court. It didn't list its hearings publicly. You had to have a battle in order to be permitted to have a public hearing at all, and the journalists similarly had to make applications to be allowed in. It applied what one former spook has called the Ronan Keating doctrine, that you say it best when you say nothing at all. And they were very unwilling to adopt the ordinary trappings of open justice. It's a bit different now. This is their website. They trumpet the fact that they are an ordinary court, and they hear arguments on both sides without risk to national security whenever they can. So at the moment, it's an inquisitorial tribunal. It's not like an ordinary common law court. Because they have to hear secret evidence, they will investigate things for themselves, which means, as Barry says, they will often disappear for a period of years before they announce that they'd like to hear from you. I don't know why it keeps moving, never mind. It conducts its own inquiries. Sometimes it appoints an investigator from IPCO, the oversight body. It will routinely conduct hearings in secret. Originally, there was no right of appeal, and there was, so they said, no right of judicial review because of an ouster clause. The Supreme Court has decided that the ouster clause doesn't work, and there is now a right of appeal that's been introduced by Parliament. So it's been linked to the ordinary court system. They now have a duty to give reasons where they can. They can't always. And they also now have power to award damages, and they may or may not have the power to award costs against the security and intelligence services. but for a complainant, going to the IPT is always free, and costs cannot be awarded against individuals. What's less good? It's still exceptionally slow. It took 6 years to determine Barry and Trevor's case, and it's still going on. The procedures are exceptionally complex. Even when a hearing is heard in public, there'll be numerous preliminary hearings arguing about disclosure, which are exceptionally difficult to manage. Most people who go there still get no reasons at all, and you don't have an advocate who is security cleared who is able to see the secret material for you. There is a counsel to the tribunal who will try and represent your interests, but there is nobody you're able to select to see the secret material. So when I represent an individual in the IPT, I see no more than they do. So just to give an example of the protection of lawyers in the Investigatory Powers Tribunal, this is Abdul Hakim Belhaj on the right, and then Sami al-Sadi and his daughter on the left. They are respectively the emir and the religious leader of the Libyan Islamic Fighting Group. The Libyan Islamic Fighting Group is a proscribed organisation, or it was, and it does exactly what it says on the tin. They were both, or actually all three of them, were detained in a joint MI5 and CIA operation, and they were shipped back to Colonel Gaddafi's Libya as part of the deal in the desert in order to obtain various advantages from Gaddafi. And this was the prize. They were obviously tortured when they got there, and unwisely for MI6, the memos and the faxes which they sent to their Libyan counterparts were still there in the Libyan archives when Mr. Belhaj was part of the forces which kicked out Gaddafi and took over Tripoli in around 2012. So he went and had a look at his file, and Human Rights Watch published his file. He then sued the United Kingdom government in tort, just an old-fashioned, boring tort claim. But as the leader of a proscribed organisation, he was obviously a bit concerned about whether he could have frank conversations with his lawyers. So he put in a claim to the Investigatory Powers Tribunal, asked for disclosure of the policies of the agencies. This is MI5's policy, which they were unwise enough to write down. There is no requirement to erect internal Chinese walls between the lawyers for this purpose, and that is, you see the question, if you see, for example, intercepted material, which is about a case you're advising on, do you have to withdraw from that case? The answer is no. You can go ahead, you can read it, even though it's the other side's privileged legal advice, which is pretty extraordinary, because if somebody is suing one of the security intelligence services, they will often end up collecting through intercept lots of relevant material, including perhaps your legal advice, and they took the view internally that they were allowed to read it, and not just read it, but the lawyers on the other side within MI5 were allowed to read it. And they gave an example. So let's say someone's subject to criminal proceedings. If you get a forensic report which is privileged, then let's put the report into the database and use it, but we won't pass it to the police. So the whole point of legal privilege is to encourage lawyers to be able to talk to their clients frankly and give them frank advice, and to encourage clients to be able to talk to their lawyers and give them frank advice. And in these type of circumstances, then obviously you can't do that. So after fighting the case for a bit longer, it was then conceded, inevitably, and the IPT produced a judgment explaining that GCHQ had indeed collected some privileged material belonging to the claimants, and there is now a new code of practice and some new legislation which hopefully has at least in part addressed that problem. So the IPT was able to improve the quality of oversight and the protection for lawyers there. Then Trevor and Barry's case for journalists. They always look very good standing outside the Royal Court of Justice, and they practice their serious and angry faces before they go, I'm sure.
That's not us on the Land Rover.
I'm told that's not them on top of the Land Rover. I think in the audience today we have Bill Goodwin. Bill was held in contempt of court by the House of Lords because he wrote, and I apologise for this in advance, a not hugely exciting article in a trade journal called The Engineer, The European Court of Human Rights took up his case, and they found that his conviction for contempt for refusing to disclose his source was improper, and they set a very high test, and it's that test that was applied by the Investigatory Powers Tribunal in Trevor and Barry's case. And what they said is that in Goodwin is that there had to be an overriding reason of public interest to require disclosure of a journalist's source. PSNI didn't apply that test at any point on the 5 occasions in which they went after Barry and on the many occasions in which they went after Trevor. So they lost, and it wasn't ultimately much more complicated than that. PSNI were also required to disclose that they had conducted a surveillance operation, and that was the real purpose of the arrest. It was to create a bit of shock and awe and excitement, and to arrange for the suspect to be followed around to see if the suspect was silly enough to meet with the 2 journalists. It has triggered a partial inquiry in Northern Ireland by Angus McCulloch, King's Counsel, but the IPT proceeded in the IPT's way, and it is a strange place for a lawyer to litigate. You still have a funny mixture of public and private hearings, and you're often kicked out for many hours, and you have no idea what's going on. Often you'll come back after being kicked out for several hours, and you get handed a piece of paper. This is one of the pieces of paper that I got handed. Proposed open form of words re Ellis. Mr. Ellis was the chief investigating officer who was seconded to PSNI. In the closed hearing, that's the secret hearing, Mr. Ellis was asked what the closed evidence he wished to refer to in relation to investigating lawyers. He'd expressed some concerns about the lawyers who were in the case. He repeated what he said in open, and then in the closed hearing said that examination of electronic equipment from the applicants was reference to Mr. Murphy, that's one of the solicitors, selling a firearm. I confess I read this and I thought, oh, bloody hell. My solicitor, or one of the solicitors in the case, there is closed evidence that suggests he's been involved in handling firearms. Oh my goodness, Northern Ireland, this is the last thing I need. This does not look great. No further information was provided. And you're handed this 2 minutes before the tribunal come back, having been kicked out for several hours. Fortunately, Niall Murphy kept his WhatsApps. We were also given the date on which this happened. Here's the relevant WhatsApp sent by Barry. The only crime being his sense of humour. Do you know anyone interested in a 9mm? With 2 clips and about 20 shells. There's the 9mm spanner, the 2 bulldog clips and the 20 seashells. It's a joke that perhaps works better in Belfast. But this was the basis on which, although the IPT hadn't seen the material, they were told in a secret hearing that one of the solicitors had been involved potentially in the acquisition of firearms. And that's the danger of these hearings and the need for great caution about them, because unless you actually hear both sides, and this is the famous statement to that effect, there's always a risk of things going horribly wrong. So what next for the IPT? I suspect this is what's next for the IPT. Last week it was reported in the Washington Post that Apple have been ordered to create a worldwide system of decryption for its encrypted iCloud service. So if you have an iPhone and it uses iCloud, Apple have just been served with a notice requiring that material be decrypted on request. Such notices are meant to be secret, so of course it was immediately and inevitably leaked. The government is maintaining its usual neither confirm nor deny approach as to whether the notice exists. But like Spycatcher, once you can read about it in the papers, there's not much point in pretending. The first task I suspect the IPT have will be to decide whether the notice should still remain secret, and then I imagine it will inevitably have to hear a challenge to it, either brought by Apple or brought by others who use Apple services. So I was hoping to have retired from the IPT at the end of this case, but it remains to be seen whether I'm going to succeed. Thank you all very much. Amanda, do we have time? Are we asked
I think we
questions?
do. I'm sure you've got questions, but before I open the floor, I just want to take 2 things. One, No Stone Unturned is available on YouTube, and it is worth a watch. And this is available outside. It's absolutely compelling. it is a really deep dive into the circumstances that Trevor and Barry have weathered. I believe that in addition to telling the RUC you were naming the suspects, that you also told the suspects that they were to be named in the film.
We
Is
did.
that correct?
On 2 occasions.
There you go. Great. I thought that's what had happened.